When can contracts be broken? I answered in a different question, which we'll link to down below, that they can be broken when there are no damages. That's one scenario. Second, contracts can be broken when they're impossible to perform. Not impractical, but impossible. Let me give you an example of that. Let's say you said, Aaron, I will pay you $500 to be on this ship, which departs on Friday and will arrive at its destination on Saturday. I'll pay you $500 to be on that ship. Well, let's say that ship never made it to the United States, so it's not going to be here on Friday, and it can't possibly depart on Friday. It's impossible for me to perform that. That is a scenario of impossibility. Impossibility is a lawful excuse for not performing under a contract. But impracticality is different. Let's say, for example, I offered to sell you 4 electric bikes for $1,000 a piece, so a total of $4,000. And I did that based on my belief that I could get those same bikes for $700 a piece. But let's say I later find out that they're now $1,500 a piece. Well, it's impractical for me to fulfill that contract because I will actually lose money on the deal. Is that a valid reason to get out of a contract? No. Impracticality is not. There are some scenarios there that are kind of in the gray area. Let's say, for example, I said, I will hire you to dig a trench from my house to my garage. It needs to be 10 feet deep. And you say, all right, I can do that. It'll be $1,000. Let's say hypothetically, as you are digging through, you run into some solid rock and you find out it's going to cost you $10,000 to get the equipment needed to go through that rock and actually drill or excavate that trench for 10 feet. Is that impossible or impractical? Well, it's impractical. But here's the thing. Neither one of us knew in this hypothetical that there was going to be solid rock there. We both reasonably assumed that it's just going to be some dirt, sand, clay. And so in that sort of case where there was a mutual mistake regarding the understanding of the performance of the contract, mutual mistake is a reason that you can get out of a contract, or contracts can be broken. Not unilateral mistakes, so not when one party makes a mistake, but when both parties make mistakes, usually performance of that contract is excused. There is also one other reason when a contract can be broken. If the other side materially breaches the contract first, then you don't have an obligation to perform your part of the contract. I'll give you an example. Let's say the contract says, if you pay me $1,000, I will give you 10 t-shirts. And let's say you had to pay me the $1,000 on Thursday, and I give you the 10 t-shirts on Friday. Well, if you don't pay the $1,000 on Thursday, I don't still have to give the t-shirts on Friday. You failed to do what was at the heart of the agreement. Your essential obligation in the agreement was to pay me money for those t-shirts on Thursday. And if you didn't do that, I'm relieved from having to give you the t-shirts on Friday. But let's say you gave the payment of $1,000 on Friday morning at 5 a.m. instead of on Thursday. Then the question was, well, was that really a material breach? It was a breach. It was delayed. But if it didn't make a big difference, it's an immaterial breach. Sometimes contracts have a clause which goes like this: time is of the essence. That is a magic legal phrase which means you must pay exactly by the time required, or you must perform exactly at the time required. And if you're even a little late, it's a material breach. But if a contract doesn't have a time is of the essence clause, then a slight delay in performance is usually considered an immaterial breach, or the type of breach that doesn't matter much. So the other side is not excused from performing. Let me give you an example of one more material breach. Let's say that a county fair hires a printing company to print flyers to be delivered in mailboxes before the fair to publicize the fair. And let's say that the flyer has a really big mistake on it. Maybe they accidentally had profanity, maybe it has the wrong date, maybe it has some embarrassing errors, whatever it is, the flyer has a big mistake. The printing company will argue, hey, we did our part. We produced a flyer. Yeah, we made some mistakes, but that was just a little bit of ink on each one. We generally fulfilled our obligation here. Does the county have to pay for that? That flyer would probably be a material breach, because assuming that it wasn't the flyer that the county ordered, and in that case, even though a flyer was produced in time, because it did not follow the specifications required by the county, that would probably be considered a material breach, and the county would be relieved of paying for that. But let's say there was a slight grammatical error, or a period was missing where it really didn't matter. That would be a breach, but it's immaterial. It's insignificant. It really doesn't matter. And so the county would have an obligation to still pay, even though there was an insignificant breach. That is why it is so important to figure out, is a breach material or not? Usually it takes an attorney to figure it out. The test is, did the breach go to the heart of the agreement? Did it go to the essential expectation of the party? If the breach did, and the party's essential expectations are violated, then the breach is material, and the other party is excused from performing. So, when can contracts be broken? When they're impossible to perform, when there's mutual mistake, there are no damages, and then finally, when there is a material breach of the contract. The other side doesn't have to perform. All right, we have covered a lot of topics here. I look forward to the next live Q&A. If you haven't already, subscribe at aaronhall.com/free. You are welcome to check out our channel where we have all sorts of other questions from business owners and the answers provided to you. I do these videos as a public service, as a way to use my knowledge as a licensed attorney to help business owners avoid problems, spot issues to discuss with their attorneys, and improve the likelihood that you will have a successful company and successful life. It was great being here with you today.